declaration that the purported dismissal of a claimant from the service of a defendant is illegal, wrongful, null and void. B, an order of court that the claimant be reinstated back to the service of a defendant with his benefits and entitlements paid. C, a declaration that the claimant is entitled to the payment of his arrears of salaries in the sum of 3,746,790 naira from July 2018, when his salary was abruptly stopped, to December 2020, when this suit was filed, and until he is finally reinstated back to office. D, an order of court directing the defendant to pay 440,000 naira free medical refund bill that the claimant is ordinarily entitled to as a staff of the defendant company for the year 2018 to 2020. E, an order of this honorable court that the defendant paid to the claimant the sum of 150,000 naira annual leave bonus the claimant is ordinarily entitled to for the year 2018-2020. F, 10 million naira damages in favor of the claimant for the embarrassment and the emotional trauma suffered by the unlawful dismissal of the claimant by the defendant. And G, 10% interest on the judgment sum until the final liquidation of claim. Although the defendant entered appearance in this case by way of physical appearance made by learned counsel for the defendant, one Abdurrahman Issa Esquire, on the 19th May 2020 to cross-examine the claimant, it is on record that the defendant has since then failed to file any process in the suit. The claimant opened his case and testified for himself as CW by adopting a sworn deposition, and he tendered documents admitted and marked as Exhibit A to A4. In accordance with the rules of this court, learned counsel on behalf of the claimant filed his final written address after the close of trial. I've reduced that into the body of this judgment. I will now go straight to the decision of the court. I've carefully examined all the processes filed by the claimant as well as documents tendered. It is in my considered view that the vexed issue begging for the court's intervention and determination is whether or not the claimant has proven his case to be entitled to the relief sought. Let me start by addressing the manner learned counsel for the claimant, BM Musa Esquire, cited an authority in his final written address. Learned counsel, while arguing on the combined issues at page 44 of his final address, cited the case DOS in Doe versus YU Supra. It is imperative to state that learned counsel had not prior to that cited this judicial authority in the address to warrant the use of the word quote unquote Supra. Learned counsel failed to include the year the authority was reported or the particular law report that reported same. He merely cited the case without quoting from the said decision. Learned counsel owes it a duty to this court to cite the authority correctly if he wants the court to consider same. Where an authority is reported, as in this instance, the name of the law report, the year, the volume, and the page must be cited by counsel. Say the case of Oni and others versus Governor of Ekiti State and another citation captured, the case of Chidoka and another versus First City Finance Limited citation equally captured. To dump authorities on the court without clear reference is wrong and unacceptable. The said authority is therefore discountenanced. Before going into the merit of this case, it is equally important to state that the defendant in this case failed to neither file a statement of defense nor lead any evidence in defense suit. Although learned defense counsel did cross-examine the claimant, yet he did not call any witness and also did not object to the documents tendered by the claimant. The law is settled that a defendant who failed to file a statement of defense is entitled to a hearing before the court, even though he cannot lead evidence. The effect of this is that the defendant's right to address the court is deemed forfeited. However, he can reply on a point of law arising from the claimant's pleadings without necessarily filing a defense and adducing evidence. He may decide to rest its case on the claimant's case and simply wish to address the court on the issue raised in the claimant's final address. See the case of Majekotumi and others and Gunshaye citation captured. The case of Main Street Bank and Yao citation also provided. The law is tried that the effect of a failure of a defendant to file pleadings stand unchallenged and are deemed admitted and established. Say the cases of O'Malley and Federal Ministry of Lands, Housing and Urban Development and Orders, citation provided. The case of Consolidation Resources Limited and Abafa Ventures Nigeria Limited, citation also captured. However, I am mindful of the fact that the claimant believes are declaratory in nature, which falls within the exception to the rule of admission due to the fact that it is the law that the claimant must rely on the strength of his own case and not on the weakness of the defendants. In the case of Alhaza and another, Al-Hassan and another versus Ishaku, citation captured. The Apex Court per Rose Bible GSC, now retired, stated those, and I quote, Section 20 and 21 of the Evidence Act provides for admission. Admission in pleadings are a waiver of all controversy on the fact the pleader admits. However, the exception to this is where the plaintiff or claimant or petitioner seek declaratory reliefs. It then becomes a different kettle of fish. The law is settled that declaratory reliefs cannot succeed on an admission by the opposing side. The reason is that a declaratory action is discretionary in nature. It is a species of civil action whose purpose is to seek an imputable relief in which the plaintiff prays the court in the exercise of its discretionary jurisdiction, promote or declare an existing state of affairs in law in its favor, as may be discernible from the averments in the statement of claim or pleading from the claimant. Hence, the onus of proof here lies on the petitioners. They must succeed on the strength of their own case and not on the weakness of the defense, except where the case for the defense supports the respondent's case. See also the case of Hachi and another citation captured. Accordingly, the claimant is required to prove his case, but with a minimal proof. Thus, the court will consider the claimant's testimony and documents tendered in proof of his as merit. Please mute yourself. Mute your tablet. Yakubu Seriki, mute your phone. It is needful for me to state here clearly that there is a clear distinction between termination of a contract of employment and dismissal. This is pertinent in view of the use of both words interchangeably by the learned claimant counsel in the pleadings and final written address. Termination gives the parties the right to determine the contract at any time by giving the prescribed period of notice and payment of salary in lieu and other entitlements. Dismissal, on the other hand, is preceded by a disciplinary measure, which is as a result of a misconduct. It carries no notice and without benefits. See the case of UBN and Soros citation captured. I find it plain on record of this case that the claimant's employment was terminated and not dismissal as alleged by claimant counsel. I so find and hold. Now to the crux of this case. There's no doubt that the relationship between parties in this case is that of master-servant relationship, wherein the master reserves the right to terminate the employee's employment provided it is done in accordance with the provision of the employment contract. See the case of Shuaibu and others and Nigerian Breweries PLC, citation captured. The case of CCG Nigeria Limited and Bakari and another citation also captured. Claimant in this case averred that his employment was terminated in June 2018 without giving any reason for the termination of his employment. The said letter of termination is herein as Exhibit A2. Dr. Jambak, I had a little interlude with my internet connection, so I'll continue from where I stopped. I think I'll go back to the quotation again. I quote, I'm quoting the decision of the court in the case of UB, Union Bank and Salahuddin. The question that now agitates my mind is whether the words for service no longer required qualify as a reason as to require the appellant to establish by evidence. This scenario occurred in the case of Nitel PLC and Aqua, where my Lord Sanusi JCA, as he then was, said the effect of judicial decisions, some of which I cited above, simply means that master employee not to be committed by the employee in terminating his appointment. In other words, even if the employee was never involved in any, his employment can still be terminated. The phrase, quote and unquote, your service is no longer required amounts to giving reason for the termination, which requires the employer to justify, is stretching the meaning too far, unquote. It is clear from the above reasoning of the appellate court that where termination is for services no longer required, the law is settled that an employee claiming wrongful termination from employment must plead and prove the terms and conditions of his employment and the manner in which the said employment was breached. Thus, such an employee must found his or her claim on the contract of service. See the case of Okomo LP Palm Company Limited and Share, citation captured, and the case of AGI and CBDA, citation provided. Every contract of employment contains the terms and conditions that will regulate the employment relationship, such as terms on determination, notice, wages, and benefits. This may be contained in the letter of employment, employee's handbook, or any other document so called and agreed to by the parties to be the contract. In proving any employment relationship, the employee must tender the contract of employment to show that such relationship exists between both parties. See the notorious case of Lungia and FBN PLC, citation captured. By virtue of the provisions of sections 131 and 133 of the Evidence Act 2011, he who asserts must prove. This is because the party who desires judgment to be given in his or her favor must prove the existence of such facts. See the case of Akimbade and another versus Babatunde and others, citation captured. Claimant during cross-examination maintained that his employment with the defendant is a permanent one. In proving his assertion, he tendered Exhibit A, which is consisting of letter of provisional confirmation of appointment letter dated 26th of April 2016. The law is settled that documentary evidence is a hanger on which to prove the existence of oral evidence, making it more credible. See the case of Oyewusi and Olagbami, citation captured. The case of First Bank and Azifa Oku, citation also captured. Claimant pleaded his letter of employment Exhibit A, which contains a few but not detailed terms and conditions due to the fact that it made provision for termination for when an employee is under probation, which is by giving him 2 weeks notice or payment of 2 weeks salary in lieu of notice. It is on record that the claimant's employment has been confirmed by the defendant via an internal memo dated 26th of April 2016. The import of this is that he is to be given a notice before termination, which should be above the 2 weeks notice for unconfirmed staff. From the foregoing, it is clear that the claimant was a permanent employee of the defendant and having worked for the defendant for almost 3 years, is therefore entitled to 1 month notice or 1 month salary in lieu of notice, going by the law, the common law position, which requires that a reasonable period of notice should be given to an employee, considering his position as the defendant and the number of years put into the employment. It is in the light of all this that I find that claimant is entitled to at least 1 month notice of termination. Now, the question that comes to my mind is that, was the claimant given any notice before his employment was terminated by the defendant? Going by the exhibit before this court, I cannot find any document suggestive of a notice of termination or payment of salary in lieu of same, which is entitled to before termination of his employment by the defendant. Failure to either give him a notice or pay a salary in lieu of notice is a breach of the terms of the claimant's employment. See the case of Ibama and SPDC Nigeria Limited citation provided. I've held that the claimant's employment is not one that enjoys statutory protection, but one of master servant employment, the termination of his appointment, but the defendant failed to give him the required notice. It is in the light of this that I find that the termination of claimant employment is wrongful. I so find and hold. Claimant by his B seeking for an order of this court reinstating him back to the service of the defendant. I've held supra that the claimant's termination is wrongful. However, in a situation where it is clear that the employer would not want the service of the employee, the court should be minded towards granting an order of compensation instead of making an order for reinstatement. This is in view of the tried position of the law that a willing employee cannot be forced an unwilling employer. The law is equally of common that in an employment of master servant, as in this instance, the court cannot make specific performance of the contract. Say the case of Olali Kwan Management Board, University of Maiduguri Teaching Hospital, citation captured. It is in light of the above that I find that the claimant's prayer seeking for reinstatement back into the defendant's service is not grantable. Accordingly, Relief B fails. Claimant by his Relief C seeking a declaration that is entitled to the payment of his arrears of salaries of 3,746,790 naira from July 2018, when his salary was abruptly stopped, till December 2020, when he filed the suit. It is tried that monetary claims are in the realm of special damages and must be specifically pleaded and strictly proved. See the case of Ajigbo Tosho and RCC citation captured. The Court of Appeal, per Sumani JC, held thus in the case of HGR Limited and Beacon Limited. I quote him. The law is that claims for salaries, allowances, bonuses, emoluments, and so on are in the nature of the special damages. Like in all claims for special damages, they need to be pleaded with particulars and evidence led thereon before they could be granted. Unquote. He continued at pages 20 to 21, paragraph H to A, thus, and I quote him again. I must observe in regard to this matter that the respondent with regard to her pleading has neither pleaded satisfactorily her special damages, to which the salaries, allowance, and other benefit that is accruable to her as pronounced by the lower court in its judgment, nor have these items of special damages been specifically proved. Nonetheless, the law is right that unless pleaded and strictly proved, the court is not obliged to make an awards in that regard for special damages, unquote. I've held supra that for declaratory reliefs to succeed, the claimant must rely on the strength of his case and not on the weakness of the defendant. Now, the question that comes to mind is that, has the claimant proven that he is entitled to the said sum of money? I am of the view that the termination of claimant's employment took effect from June 2018. And as such, there's nothing before this court showing that he worked for the defendant during that period to be entitled to that amount of money. The law is settled that an employee cannot claim for payment of salary for work not done. See the case of Kunika Sawmill Nigeria Limited and Hoff, citation captured. It is in the light of the above that I find that relief C also fails. Claimant by his relief D is claiming for the sum of 441,000 as free medical refund bill. The claimant's relief for refund of medical bill presupposes that he was sick and had medical issues that requires payment of bills. Though by paragraph 4 of the claimant's letter of employment, which is held out to be the contract regulating his relationship with the defendant, it provides that claimant is entitled to free medical treatment to the tune of 30% of his annual basic salary. Claimant who is seeking this relief has failed to substantiate his claim. The medical treatment is not granted as a matter of course. Claimant has to show that he was sick, he sought medical attention at the hospital, and incurred some medical costs by tendering such bills. There is no single evidence on record to justify the grant of this relief. He tendered a document titled Medical Bill Refund, IDES Exhibit A3, on record, addressed to the head admin/HR, dated 13th May 2018. There is nothing on the piece of paper to evince that it was received by the defendant, talk less of its approval of same. It is in view of lack of proof of relief D that I discountenanced it. Relief D thus fails. Claimant claims for the sum of 150,000 naira as annually as per his relief E for year 2018 to 2020. The law is tried that he was said must prove. The claimant seeks for payment of leave bonus, has the honors of satisfying the court that is actually entitled to this claim. I find no single evidence to show that claimant do entitled to 14 days leave and 10% leave allowance of his annual basic salary embarked on the leave or was not paid leave allowance. He equally failed to justify the sum of 150,000 naira claimed. Consequently, I find and hold that claimant has failed to prove his relief E. Accordingly, claimant's relief E equally fails. Claimant also is claiming 10 million naira damages for the embarrassment and emotional trauma he suffered. There's no doubt that this case is that of wrongful termination or dismissal. Wrongful termination. I've held hearing that the defendants did not comply with the terms of the contract before terminating claimant's employment. As a general principle of law, the remedy available to the claimant for wrongful termination of his employment is of notice, except where the termination carries with it some kind of a stigma that has impugned on the character or person of the employee. In such a case, the court may, in addition to the salary in lieu of notice, award an additional damage. See the case of British Airways and Mark Controller, and the recent case of Sahara Energy Limited and Ebola citation captured. I find no such stigma in this instant case. I equally find no evidence to justify the emotional trauma or embarrassment the claimant allegedly suffered to warrant the grant of 10 million naira damages sought. It is in the light of all facts and circumstances of this case that I find that the only damage claimant is entitled to is 1 month's salary in lieu of notice. By claimant's pay slip herein as Exhibit A4, claimant's monthly salary, gross monthly salary as at April 2018 was 149,363 naira 85 kobo. It is in accordance with this that I award the sum of 149,363 naira 85 kobo as damages to the claimant. I so award. Claimant is also praying for 10% interest on the judgment sum to be awarded until the final liquidation of same. By the provisions of Order 47, Rule 7 of the rules of this court at the time of delivering judgment or making an order may order for payment of interest at a rate not less than 10% per annum to be paid upon the judgment sum. Clearly, the provision vests the discretionary power on the court to make an order as it deems fit. It is pursuant to Order 47 of the rules of this court that I hold that the judgment sum be paid to the claimant within 30 days of this judgment, failing which it is to attract 10% simple interest per annum. For the avoidance of doubt and the reasons earlier given, I declare an order as follows. 1, that the termination of claimant's employment is wrongful. 2, that claimant's reliefs B, C, D, and E fail. 3, that the claimant is entitled to the sum of 149,363 naira, 85 kobo as 1 month salary in lieu of notice. 4, I award cost of 50,000 naira to the claimant. 5, the judgment sum is to be paid to the claimant within 30 days, failing which the defendant is to pay 10% simple interest per annum on the judgment sum. Judgment is accordingly entered. A copy of the judgment will be sent to parties at local level. Are the cases in Lokoja going on or not?
Yes. It's going on. Yes. Answer that. Yeah,
well, I have the learner's stick before me here in Abuja. So I will stand down for Lokoja and take the learner's stick matter and then come back to you. I'll give you a prompting immediately that is done. Is that okay?
no choice.
So I will stand down, I will rise for a few minutes in Lokoja. I'll return back to you.
As the court is